Hello, welcome. Welcome to this APIL webinar. We are looking today at how to recover your success fee on the approval of settlement by the court. Although I should probably say that perhaps this might want to be titled how to help improve your prospects of recovering a success fee on approval of a settlement, because this does seem to be something that a lot of us have had problems with, and indeed experience varying between different courts. Just to set the scene a little bit, practitioners might be forgiven for thinking that there is something of a disconnect between the recommendations of the Jackson report implemented by LASPO, which transferred the payment of additional liabilities from defendants, generally speaking, to claimants. And the practice of many courts that seems to be an unwillingness to fund the liability of litigation friends, so far as costs are concerned, out of damages paid to claimants who happen to be children or protected parties. And again, just by way of setting the scene, it's worth observing that APIL and many claimant practitioners, claimant groups actually urge the government not to remove the recoverability of additional liabilities, at least from protected parties. But Parliament, and we live in a parliamentary democracy, decided otherwise, and now all of us have to work with and live with the problems that has caused. I think it's also worth remembering that recoverability, and more about the criticism of the recoverability of additional liabilities in a moment, but recoverability was introduced to justify the withdrawal of legal aid, and the theory at the time was that recoverability would redress the balance between claimants and defendants, because success fees on winning claims, which would be paid by defendants, would help offset costs incurred but wouldn't be recoverable in claims that lost, because of course claimant practitioners otherwise wouldn't be paid at all for those, and defendant practitioners would be paid for all the work that they do. And so that doesn't really detract from the general principle that the losing claims needed to be funded, and really all the most recent reforms do is make that cost be borne by the pool of successful claimants rather than unsuccessful defendants, and that's really important to preserve access to justice. So we're not trying to look here for any super profit or anything like that. It's about having the resources necessary to ensure that the pool of claimants are going to get access to justice. So the aim of this webinar is to try and help you think about how we can best achieve that and deal with things in the way they are rather than how we actually might like them to be. So I think we need to start by looking at where we are, the problems that we're facing, and actually go back to square one in terms of running a case, because really getting it right at the end all begins with getting it right at the beginning and having the right funding arrangements in place, as I hope we'll see. Now, just a reminder before we go further that if you have a question, please type it into the box on the screen, press send, and I'll try to deal with as many of those as I can towards the end of the webinar. Right, so what are we going to cover? I've given you a bit of an idea of the problem that we face, and I want to expand on that by looking at the background to LASPO. And I think these are not unimportant points when you're actually at court arguing there should be a payment out of damages, because the courts sometimes need to be reminded how we've got to where we are, and this is not us, it's dealing with the system that we now have. So the background to that, and why we had LASPO in practice, and I want to just flag up some of the problems practitioners have had on this very topic. I want to talk about caps and how they actually apply, because there can be some confusion. The related but separate topic of ATE premiums, trying to recover the policy, and then we'll get on to the nuts and bolts, thinking about how you would get a pre-issue settlement approved and how that's different from a post-issue approval, and then the real key point, when and how to deal with claiming costs and expenses in those cases where approval is being sought. I'll look at what tactics and arguments might work, and those that certainly won't work. And then almost back to where we started with client care and managing expectations, because it's really important to keep client focused throughout all of this. So let's start off and try and work our way through these issues. And I want to just start with a little bit more of a background to LASPO, get some terminology right, because these are really important things to understand and be ready to deal with at any hearing, because it can get rather mixed up. And a point, as I've said, forcefully made by claimant representatives before LASPO even came in, was that damages for injured people have always been calculated on the full compensation principle. So claimants are going to get no less but no more than the damages that they need to be in the position they would have been in if not injured. Now, I suspect this is on the mind of the courts very often, dealing with children, dealing with protected parties, but really they're no different position now to any other claimant, because as we shall see, it was the result of the Jackson report and government policy. Those people should make a payment towards damages. This is not a claimant-driven change. We didn't want that to happen, but it's where we're at, and the courts really need to follow that. So there was always going to be, I guess, when you look back on it, an issue about children and protected parties, because the court would have to actually authorise a payment out of the damages to meet those irrecoverable costs, and traditionally most practitioners wouldn't make a charge, although they would have been entitled in many circumstances to have done that. So perhaps the courts have got used to no charges being made. So under LASPO, which was very much seen by the government as creating some sort of market, that was always the phrase that was used, it won't be possible to recover all the costs, but if you like to make the market effective, then the claimant, using the government principles, has got to make a payment, or else there isn't going to be that market at all. So some of the terminology, just to remind ourselves with this. Base costs, first of all. So they're essentially the hourly rate that may be agreed with the claimant applied to the time actually spent dealing with the matter. A success fee, well, that will be an uplift expressed as a percentage on those base costs. And as you well know, the success fee, and we're going right back to the Courts and Legal Services Act, that cannot exceed 100%, and that means 100% uplift on the base costs. Now, prior to LASPO, both base costs and success fees were potentially recoverable as party and party costs. Now it's only the base costs. Well, that leads on to the distinction between party and party costs and solicitor and own client costs. And it's a crucial distinction to remember, because the client will have agreed as part of the CFA to pay costs in the event of a win. So the obligation to pay, that's the condition, will be triggered by winning the case, which will normally mean the recovery of some damages. So the definition's a little broader than that. And strictly those costs are payable whether or not they can be recovered from the paying party. That is the issue of party and party costs. What are those solicitor and own client costs? Because you've got to have that obligation in there for those costs to be paid, will be indemnified by the paying party. And those costs will almost invariably be less than the solicitor and own client costs. Worth emphasising that fixed cost schemes, they are concerned with party and party costs. They do not fix solicitor and own client costs. That is, unless the solicitor chooses to say in the CFA or other retainer, the client will only be charged fixed costs, and as we'll see a little later, probably not a good idea. Better, generally, to have the agreement to pay the hourly rate according to the time spent, but limit any exposure by a cap, which again we'll turn to in just a moment. So these days, when we're thinking about party and party costs, those will be base costs. You can't recover the additional liabilities, including the success fee, and so that will remain part of the irrecoverable solicitor and own client costs. So the subject to caps, and this really is the way of protecting the claimant, and although the government of the day was very keen to see a market for legal services, they wanted protection for claimants, so we saw a statutory cap imposed on the success fee. Now, this is where it starts to get complicated because that cap relates to the amount of damages recovered. So you can have a 100% success fee, but the amount that you can actually recover from the claimant will be, at least at first instance, limited to 25% of general damages and past expenses and losses. So the linkage there is in relation to the damages. The cap, incidentally, doesn't restrict solicitor and own client costs that can be recovered, and that's why many solicitors will actually operate an overall cap, which they will apply. And that is probably the safer way of protecting the client and not putting in some fixed costs into the CFA. So why did we have LASPO? Two things really, Jackson report and government policy. And it's worth just reminding ourselves what Sir Rupert Jackson actually had to say. It's quite relevant when you're perhaps seeking a payment out of irrecoverable costs. I put on the slide what I think are the most relevant paragraphs. Just take you briefly through these and leave you to have a look at those. But paragraph 110, where Sir Rupert expressed the view that it might be to the dismay of claimant lawyers, but he did not think that recoverability of additional liabilities should continue. 330 is quite interesting because Sir Rupert there quotes a counsel of Her Majesty's Circuit Judges who said this: the concept of a losing defendant in any particular case having to subsidise the costs which the opposing solicitor has notionally or actually lost in other cases is manifestly unfair and could be called grotesque. So, not liking the idea at all of the defendants paying and supporting passing that on to claimants. Well, if that's the case, then when push comes to shove, is there going to be a payment out? Well, it probably needs to happen. It really follows from that. Similar remarks attributed to the Chief Chancery Master in paragraph 331, who talked about the defendants paying additional liabilities as an iniquity. So 420, Lord Justice Jackson recommended abolishing recoverability, but crucially in 5.3 said these are the things he's going to do to give something back to claimants: the 10% uplift on general damages for pain, suffering and loss of amenity, capping the success fee, so some client protection, and also, very importantly, Part 36 changes, giving the claimant additional Part 36 benefits. Paragraph 5.7, he looks ahead to the latter part of the report where he'll recommend those changes that would give those claimant benefits, which again we need very much to bear in mind because quite often a claimant will have secured those benefits, and that may be relevant to then saying, is it appropriate for a payment to be made out of court? And indeed, in paragraph 5.8 of the report, Sir Rupert said that this will substantially assist claimants who have to pay success fees. Just going on then to the benefits that claimants get, very important we don't forget them, the 10% uplift enshrined in case law, as you know, by Simmons and Castle. So you always want to be seeking that additional 10% on damages for pain, suffering and loss of amenity. And also Part 36 and paragraph 316 of the report. Very important point this, where, as you well know, Part 36 was amended. We have the new Part 36.17 that gives the claimant who gets a judgment at least as advantageous as the claimant's own offer the existing benefits of indemnity costs enhanced interest, but that 10% additional sum. Now, this is on top of the 10% Simmons and Castle, and it's 10% of all the damages. So Part 36 offers become really important. The whole idea being that if you have an intransigent defendant, you're in a position to make reasonable offers, and if they don't accept them, then they are going to be paying additional damages and additional costs. Well, that, of course, will help, as Jackson anticipated, offset the potential liability. So we need to come back and think about how we use Part 36 as well in these cases, because if you can show the court you understand these benefits, you've taken steps to try and secure them, then it's hopefully easier to get an order for a payment out. Now, tied in with the recommendations in the Jackson report, I think we do need to remember government policy of the day, because the coalition government were very much aligned with the reforms recommended by Sir Rupert Jackson, and they expressly said in their policy on civil justice reform, claimants are at no financial risk when bringing personal injury claims, and the action identified as appropriate was, and I quote, making any success fee payable by the winning party. Now, the government could have drawn a distinction between those who are litigating with capacity and those without. They didn't. And so Parliament, which could have made a different provision, in effect said all claimants, all winning parties, including children, including protected parties, will, in line with the stated policy, pay the success fee. We live in a parliamentary democracy, that is the law, and we do need to rely on the courts to apply that. Is it happening? Well, let's have a look at LASPO in practice. A lot of anecdotal accounts of courts actually refusing to make any payment out of damages, despite all the matters that we've been considering. One fairly well-known reported case is the A&M and Royal Mail Group case. This was a fixed costs personal injury case where, on settlement of the claim, claimant solicitors sought a payment out for the irrecoverable success fee and the ATE premium, fairly modest level of damages. In fact, 25% of the general damages was a figure of £516.25. Now, a good blog on this case to have a look at is that by Kerry Underwood, who of course writes a lot of really helpful stuff. If you look at his blog, he makes a very fair point that it's this relationship between the success fee on the one hand and the cap that relates to damages actually means the true success fee allowed, as claimed, is only 14%. But the district judge, in the end, directed a payment out of damages based on what was described as a success fee of 10%. Well, it was actually 10% of the damages, which, as Kerry points out, is not the same thing. And this seems to hark back to the idea, well, the claimants have this 10% uplift on general damages per the Jackson recommendation, Simmons and Castle, so that should be the limit of the exposure. But for the reasons we've seen, that really doesn't seem to me to be what Jackson had intended, or what the government had intended, or what Parliament actually enacted. And you may have found since then that your local courts seem to be adopting very much the same approach and operating on a rather broad brush 10%. And I think on these cases, when we are applying for a payment out, it's perhaps quite important we do take the courts through how this works, the nuts and bolts, the kind of things that we've been looking at, and making sure it's understood that we are doing our best to follow this new era system and how that works. Now, that really takes us on to our next topic. This is where I want to go back to the beginning of a case, because it seems to me quite important to be able to say to the court, we don't simply impose a blanket 100% success fee without any consideration about the issues, that it's actually a little bit more sophisticated than that. And you get the feeling that's perhaps one of the issues that influences the decision in the A&M case. How do we do that? Well, all cases will have generic risks. No problem with that. It's inevitable and not unreasonable to allow for that. But I think as far as you can, do try and identify specific risks, because at a later stage, one of the things that you will need to do, as we shall see, is explain to the court how you calculated the success fee. So try and identify, if you're not doing that already, what are the risks that you perceive at that time. And there is a bit of an overlap sometimes between what you might call generic and specific risks. For example, clinical negligence claims. You can say, because the NHSLA come up with statistics, that almost 30% of claims in the 10 years up to 2015 were resolved without damages payment. So it gives you an idea that, leaving aside the facts of a particular case, these cases are quite difficult. And then you will bolt on the more specific risks. Flag up Part 36 risks. You can have the CFA that provides for you to run the risk in the event of a Part 36 that you don't beat, when you don't get base fees or success fees. Well, that's a bigger risk, and it's relevant. So I think those need to be identified. And I would also suggest we don't lose sight of the importance of stage success fees. Now, you might remember these were encouraged from the early days of recoverability. Callery and Gray, the Court of Appeal, endorsed the use of stage success fees. These quite simply will recite that if the claim settles at a certain stage, then the success fee will be a particular level. That will increase as the case goes on. That's a very good way of dealing with more generic, unspecific risks that you can't predict, and so you are anticipating that there might be problems, and if those do materialise, the success will be high, but it will be reduced if in the event they don't materialise. Perhaps the case settles pre-issue. Here, of course, we're now looking at reasonableness in terms of your dealings with the client. It was the focus until recently on whether that was a reasonable success fee for the paying party, the defendant, to meet. But it's just as relevant, but now generally the issue will be with the claimant, or in the case of children and protected parties, the court, if you like, on behalf of that party regarding what is reasonable. So do a risk assessment, put the generic risks, put the specific risks, and do think about staging and reflecting that in the CFA. All of that is likely to help you later. Caps, well, the CFA will require the statutory cap found in the Conditional Fee Agreements Order 2013. That is the provision that limits the recoverable success fee to 25%, at least at first instance, of general damages and pain suffering, general damage, pain suffering, loss of amenity, and past expenses and losses. But if you do choose to impose an overall cap, so the client's fully protected, not just on the success fee, but solicitor and own client costs, that's probably a further relevant factor that can be drawn to the attention of the court as and when you're seeking an order for a payment out. ATE premiums. Well, the issue that can arise here is whether the court regards it as reasonable to have taken out a policy at all. So again, I think you're going right back to day one when you need to have spelt out to the litigation friend the pros and cons of ATE, involve them, if you like, in the decision-making process, an informed decision. That's going to be important at a later stage when you're explaining to the court this was all done with the approval of the litigation friend. It was done because it was thought to be appropriate. Also, I think spelling out to the court why ATE can still be really quite important in the new era, because we only have qualified one-way cost shifting, and we've seen a lot of arguments by defenders to try and get around quocs, as we know. And there remains the Part 36 risk. Most ATE will provide cover against that risk. And in fact, when you think about it, most cases either are going to have issues on liability, so they are risky there, or if they are a case where the risk is much lower on liability, what's going to happen? When you're likely to get an offer to settle from the defendant, it'll probably be a Part 36 offer, and that not only puts your costs at risk, particularly with the model CFA that provides for you to carry the Part 36 risk, but also endorses the need for ATE insurance. And if you go back to Callery and Gray again, talking about ATE in the slightly different context of recoverability, but really making the same general point that it was quite reasonable, given all the risks, to be taking out a policy on day one. And that has to remain a valid point in the new era. So let's move on, having thought about the kind of problems that we face, what the context within which we're working is, and some of that terminology, to the detail of how we actually go about getting approval. This in itself is not straightforward, because it's a combination of so many parts of the CPR. Let's think first of all about pre-issue approval procedure. So starting point is going to be 21.10.1 that says no settlement of a claim by or on behalf of or against a child or protected party will be valid without approval of the court. So you will need approval. If this is pre-issue, then it is covered by Part 8. Use that procedure because Part 21.10 expressly says that you can do that. And if we then think about the practice direction to Part 8 briefly, then that expressly again endorsing the content of Part 21 says this procedure can be used for approval, and that will also include where you have an apportionment of a fatal accidents claim and there are dependents with children. Now, if you are applying for the pre-issue approval, the next bit of the rules to look at is paragraph 5 of the practice direction to Part 21. This is really important because it does set out in detail the procedure. So you are making a Part 8 claim, and if this is a pre-issue application for settlement, you will need a draft consent order using the N292. You'll need details of what exactly the defendant admits, the age of the child, or details of protected party. You will need the approval of the litigation friend, and in a PI case, and that's of course the kind of claim we're concerned with today, you'll need to give details of the accident. You will need to provide expert evidence dealing with quantum. In an appropriate case is what the practice direction says, a schedule of past and any future expenses and losses. So in a more complex case, you'd certainly want a schedule. If it's a more straightforward case, then it might be possible just to set that out in a rather more straightforward matter. And if liability is in dispute, you'll need to put before the court evidence that allows the court to form a view on that. So it might be police report, inquest documentation, that sort of material. So it's actually quite a lot to put together to help the court assess the case and decide whether approval ought to be given. If we then think about the situation post-issue, well, we start in the same place, which is 21.10.1, the rule that confirms no settlement will be valid without approval by the court. But then the procedure is really quite different to a pre-issue settlement. So rather than a Part 8 claim form, we're looking at a Part 23 application notice. So you will apply in the proceedings for approval. And you're now looking at paragraph 6 of the practice direction to Part 21. That starts off by saying, in a PI case, you will need the court's approval. The court needs information about whether periodical payments would be appropriate, and if so, you'll need to explain that in more detail. This practice direction goes on to say that the court must be supplied with an opinion on the merits of the settlement by counsel or solicitor acting for the child or protected party, except in very clear cases. So there may sometimes be very modest sums that might not be essential. In most cases, it will be required. And again, you will need documentary evidence to allow the court to properly assess the case. So I think it's worth reminding ourselves of those procedures, because one of the fundamentals to actually getting the costs sorted out, not just setting it up right in the first place, but when you are seeking approval, is getting the documentation right. You're not going to get as far as costs if the documentation doesn't in fact allow the court to deal with and approve the settlement. And that takes us on to the topic we really need to focus on, which is when and how to deal with claiming those now irrecoverable costs and also expenses. So when we're talking about costs here, we are focusing primarily on the now irrecoverable success fee. Strictly speaking, of course, that could include any irrecoverable solicitor and client costs as well. But generally the focus will be on the success fee. Expenses, well, that will be any expenses the litigation friends incurred. There may be a range of sums spent on behalf of the child. The litigation friend's quite entitled to ask for reimbursement because the damages may well have covered those things such as travel expenses, prescription charges, if any, purchases, those kind of things. And actually the ATE premium, that fits in under the heading of expenses for the purposes of the rules, so it goes in there. Now the procedure to follow, and when you do this, is quite likely to turn on whether this is a fixed cost case or not. So fixed costs, that will be an X RTA protocol or EL protocol claim, or of course one that stays in one of those protocols and goes to stage 3. Starting point is that the court can, under Part 21(11), give directions for investment of the money. It will normally direct that all the monies be invested, but Part 21(12) goes on to say that a litigation friend who incurs costs or expenses on behalf of a child or protected party is entitled on application to recover the amount paid or payable to the extent that's reasonably incurred and is reasonable in amount. Now that rule's always been there to deal with this particular issue, but it was revised a little while back, and in particular new provision 1A was introduced because in practice there were being problems experienced in fixed cost cases where there would be hearing to approve the settlement, the costs would generally be fixed, and some courts were taking the view that in the absence of a detailed assessment there was really no format to sort out making an order for a payment out. So traditionally, expenses of the litigation friend and any costs that might be being recovered out of the damages, they would probably be dealt with at a later stage, the stage of assessment, now in the fixed costs era, potentially being brought forward to the point when the court is going to assess and approve the settlement. So let's think about recovery specifically of costs in a fixed cost case. And the key rule here is Part 21.12(1)A, because that says the costs recoverable under Part 21.12 include costs incurred by or on behalf of a child by way of success fee under a CFA. Also, sums due under a DBA, but let's park that because I think those really are quite rare. And it goes on to say this is where the damages agreed or ordered to be paid do not exceed £25,000 and where the costs have been summarily assessed. So two conditions really here, under £25,000, and that would generally speaking therefore be one of the fixed cost cases, and where there's been a summary assessment as opposed to a detailed assessment. Now, the summary assessment's also a relatively new provision because the general rule in Part 46 is that the court must order a detailed assessment of costs payable by or out of money belonging to a child or protected party. And that provision goes on to say when there is such an assessment, the court must also assess costs payable to that party. So the idea would be a detailed assessment that would look at the costs payable to the child or protected party by the defendant, and then what might it be appropriate to actually pay out the damages so far as those costs are concerned. Problem, of course, fixed cost cases, it's quite unlikely to be a detailed assessment, hence the introduction of 21.12(1)A, with a view to giving the court the power to deal with this issue at the approval, do a summary assessment of costs, and then deal with any payment out. It's paragraph 2.1 of the practice direction to Part 46 that deals specifically with the circumstances in which the court need not order a detailed assessment. Now, there's a number of those, but the most important ones are where defendant is going to pay the costs and the claimant's representatives waive the right to claim further costs. Now, traditionally, that was the route that was normally taken. That is now less likely because, of course, if acting on a CFA, it's quite probable the representatives will look for payment of at least the success fee, possibly an ATE premium, out of the damages. So the rule now goes on to say that you can avoid a detailed assessment where the court has given a direction for summary assessment, and then that can be dealt with all at one go. So quite complicated, as I say, because you're dealing with a number of provisions in different parts of the rule, but if you read them together, these provisions allow the court, where the only costs to be paid out of the damages belonging to the child or protected party are the success fee, and the damages don't exceed £25,000, the court can then, under Part 46, conduct a summary assessment. We'll be able to do that at the approval hearing and actually go straight on then to decide under Part 21.12, can there be a payment out of the damages. If you get that far, and we're going to think about what you need to say to the court in a short while, Part 21.12, remember, limits the costs to those reasonably incurred and which are reasonable in amount. But for those purposes, the court will have regard to all the circumstances of the case, and this is a very important point to why it's so crucial to have documented what you did when you make the funding arrangement. The court will have regard to the facts and circumstances as they reasonably appeared to the litigation friend at the time the cost or expense was incurred. So that's why you need to have illustrated why you've made the funding arrangement you have and what was taken into account. The rule, of course, recites the statutory cap on the success fee, so the 25% that's in there really just to make sure that it ties in with the conditional fee agreements order and gives hopefully then a seamless picture about how the court should approach that. Now, if you are going to follow this route and try and seek all of these matters to be dealt with at the approval hearing, it's important to be aware of paragraph 11 of the practice direction to part 21, because that outlines more documentation that you've got to file, in addition to the documentation we thought about a little while ago, this time focusing on what you need to get a payment out. So it's a copy of the conditional fee agreement, copy of the risk assessment, so back to why that is so important, why it needs to show what the risks were at the time, advice given to the litigation friend in relation to funding, so again to show an informed decision is made and that the litigation friend has weighed up the options and made that decision. Costs agreed or recovered by the child, so that might just be saying the following fixed costs are recoverable, and confirmation of the sums agreed or awarded for general damages for PSLA and past expenses and losses, so the court can see where the 25% limit is. Now, how do you do that? You may want to file actually a case summary, even a skeleton argument, that gives the court some of the background to why you're charging a success fee at all. We thought about that earlier. How you approach that, why the success fee was fixed as it was, that the litigation friend was aware of the options, made an informed decision, and actually is quite content for that sum to be paid. All of that, I think, is likely to help you. Now, recovery of costs in a non-fixed cost case, this is likely to be dealt with in the traditional way. Though, of course, until we lost recoverability, although in theory you could have claimed solicitor and own client costs, in practice that was rarely done. So again, we're in fairly new territory where we're seeking to recover the irrecoverable success fee by a payment out of the damages. But here, it's quite likely this will be dealt with at the stage of assessment of cost, detailed assessment. Though in some circumstances, you might still be able to tackle this problem at the approval stage. Now, the reason for that is, of course, 2112A is not applicable if the damages are going to exceed £25,000. It's not as straightforward as saying, well, if they exceed that sum, it will never be fixed costs, and if they're under that, it will always be fixed costs, because, of course, some cases will be under £25,000, but not fixed costs, because it's a case that would go into the portals on value, but not for some other reason, or actually it's a case that looked like it would be multi-track, but you end up with getting damages perhaps a little bit less than £25,000. Well, in those cases, there seems no reason why you still can't use 2112(1)A, and it might be useful to try and deal with this at the stage of approval. Otherwise, more likely to go to a detailed assessment when the court can look at all these issues. In effect, it'll become a party-and-party assessment if you haven't by then agreed costs, and that will also be the forum for seeking a payment out of the damages when all the considerations that we've just been thinking about, if it's dealt with at an approval hearing, are still likely to apply. The court's likely to need the same information about how the success fee was set, how risk was assessed, that the litigation friend thought about funding options, but at that slightly later stage. Recovery of expenses, just so we don't forget the ATE. Now remember, this does encompass not just the ATE, but other expenses of the litigation friend, but we're thinking about costs today, so it's really the ATE premium we need to focus on. 2112 now expressly covers, so far as expenses are concerned, a premium in respect of a costs insurance policy, so an ATE policy. Interestingly, also interest on a loan taken out to pay a premium for a costs insurance policy or other recoverable disbursements, so interest potentially recoverable as well. This is a fixed cost case, and some non-fixed cost cases, you can raise this at the approval, otherwise again it will be detailed assessment. All right, well let's move on then, having looked at the procedures, having looked at when this is going to arise, to what arguments and tactics might actually work. Now, I hope most of this will make sense, building on the things that we've been thinking about over the last 45 minutes or so. And it is all about, if you like, preparing for this stage right from day one. So what are you going to need at court? Well, the correct documents for dealing with approval of the substantive issue on damages, because if you don't get that right, you're not even going to get onto costs. And as we saw, that in itself is not entirely straightforward. There's in fact quite a lot of technical requirements about the information the court requires. Next, we need correct documentation for dealing with the cost issues. So that in particular requires a statement from the litigation friend dealing fully with the matters required by the practice direction to Part 21. So the details of the funding arrangement, exhibiting the advice given on funding arrangements, and dealing with the risk assessment. And that's where you might actually want to add to that, because you might want to be putting before the court, so I think this is more appropriately done by case summary or even skeleton argument, the policy that underpins all of this, the loss of recoverability and the recommendation of Sir Rupert Jackson, government policy, that claimants should actually pay towards the costs. So understanding why we're even making the application, why we have the system that we do. All of that, really important to get before the court, get the paperwork in on time and have it there so that the judge can understand why you're actually asking for a payment out. And I think a few points that hopefully will come out of that, but definitely worth stressing, that it's not a case, and it shouldn't be a case, of just always fixing 100% success fee and actually asking for a 100% success fee out of the damages. It's very unlikely that you'll be doing that. First, because you'll be able to show that you've tried to reflect the risks, that maybe you've staged the success fee to guard against an over-pessimistic approach and then those risks not eventuating. And also that, of course, the claimant is protected by the cap on the success fee and possibly also any overall cap that you may have been willing to apply. So it's not a case of, even if it were a blanket 100%, doubling the cost, actually any payment out will be governed and controlled as a ceiling by the amount of damages recovered. Worth reminding the court, of course, about the 10% uplift. So in theory, the claimant will always have had at least an extra 10% of the damages. But for the reasons we've seen, that really shouldn't then be equated with what do you get by way of costs, because as Jackson himself made clear, that goes part of the way towards offsetting the loss, but not the whole way. And the policy was that claimants should make a contribution. And I said we come back to Part 36. I know I talk about Part 36 every time I talk about anything, but actually it's really important here, because if you go back to the Jackson report, and I gave you the references to the paragraphs that deal with this, what he envisaged was that if you have a defendant who is difficult or not reasonable or won't settle promptly, you've got the power to make a Part 36 offer, and if you end up with a judgment that's at least advantageous, you're going to get not only indemnity costs that will help offset any shortfall, but also your client will get that 10% extra damages the whole of the damages, not just limited to pain, suffering and loss of amenity and past expenses and losses. So a further reminder, if that were needed, of why we should use Part 36, and particularly if we have defendants that are not taking a constructive approach to settlement. Just a couple more points on that, because we need to remind ourselves how this works. Don't forget, Broadhurst Town, really crucial case. In a fixed cost case, once you get beyond a claimant's Part 36, beyond the relevant period, then your costs are assessed and assessed on the indemnity basis. They're no longer fixed thereafter. And as you probably know, there is a beginning of a body of case law saying, well, even if the defendant accepts a Part 36 offer by the claimant late, then the same approach ought to be adopted. It should be fixed costs to the stage you reach when the relevant period expired, costs assessed on the indemnity basis until acceptance thereafter. Now, if the court is saying, rightly, we want to protect children, we want to protect protected parties, then they surely need to be making favourable cost orders when that very party has made an offer that could and should have been accepted sooner. It makes no sense to say the claimant doesn't get those benefits, but actually then we're going to try and protect them. They've got a way of protecting them. So do make sure that's used. And final thing that I think will work, just make sure the litigation friend's involved throughout the whole process, because you're going to be in a much stronger position at court if you can say, here is the statement, the litigation friend is entirely happy with this, has been making informed decisions throughout, understands where we're at, understands there'll be some payment and is content with that. That's a better place to be, which again takes us right back to day one. Arguments and tactics that won't work, well, it's really the opposite of all the things I've been saying. Not having the right documentation, just expecting the court to award a success fee without really explaining the background of why it's appropriate in this case, and not making full use of Part 36. We've really talked about client care and managing expectations, so it is just to emphasise the point, thinking about funding arrangements involving the litigation friend from day one, advising on Part 36, using Part 36, keeping the client involved in all of that, so that at the end of the case, that litigation friend in paper and orally, if they're there, is going to be able to confirm this is all fine, we're happy with this, and hopefully that will bolster your arguments to the court. Now, I've tried to get through that in time to just deal with some questions in the last 5 minutes or so. Let's have a look. So you do not need to make a separate application for deduction of the success fee or ATE premium can be dealt with by filing case summary. My view is that if you look at the rules, it is something that can be dealt with. You may feel that it's safest to make an application. You probably need to know what is the practice of your local court. So many of these things depend on local practice, because when you look at the rules, they're somewhat ambiguous, and if the practice is that's what you need to do, you need to do it. If they contend you don't need to do it because it's there in the rules, the court can deal with that, fine, it's going to save some paperwork. Whether you do or don't need to do that, what I think is fairly crucial is explaining why you're doing what you're doing and picking up all those various points in the practice direction in particular to explain. Just looking at other questions, really just one other thing, council's fees, are they recoverable? Well, for that, you've got to go and look at if we're talking about fixed costs, if it's not fixed costs, there won't be a problem, provided it's reasonably incurred, and it's hard to see how it wouldn't be. under the new fixed cost regime, I know there were issues under the old scheme. You should be fine with that because that will be an allowable disbursement. It's one that you will need to incur, so that shouldn't be a problem. Just make sure that that is included in the schedule of costs that you're going to send to the other side. In many of the fixed cost cases, it may well be that you're actually able to agree the costs and you're just dealing with the element of costs that can't be recovered that you want the court to pay out. That's not necessarily a given, of course, because there might be arguments on the level of disbursements, and then that's the sort of situation when a court will need to do a summary assessment. But under the new regime, if it is a fixed cost case, then the court should be able to deal with any issues relating to summary assessment, party and party, which may just be disbursements, and also the extent to which there should be a payment out of the damages and deal with that at the stage of approval. But it is unfortunately quite a problem because we're still very much in uncharted waters here. One of the very good reasons, it seems to me, why we don't need further change at this stage, because these reforms were introduced now 3.5 years ago, and here we are today looking at the problems that we all experience and still no easy answers. Let me just see if there's anything else. Well, just one question to finish on, because to me it kind of says it all. Question: a judge has recently said in an infant approval hearing that they understood the rules and had all the claimant evidence, but was not in agreement with making deductions from children's damages that would not allow a deduction. Well, fully understand, I would be very sympathetic to that, but the position is this. We have a parliamentary democracy. Parliament has decided that claimants will pay. That's why I gave you government policy of the day. That has been implemented. And the representative organisations have the opportunity of making submissions to Lord Justice Jackson, which is why I gave you some of the quotes that are in the report. And I think that was the time to make your point there. We are now where we are, and whether we all like it or not, including the courts, I'm afraid we have to live with it. And I think those kind of comments explain why actually you sometimes have to go back to basics, and you have to say, regrettably, this is why we're doing it. It's because of the Jackson report, because of government policy, and because it was the view taken by representative organisations, including representatives of the judiciary at the time. And I think that does need to be explained. Do that, and you don't get the right order, and I think you're on strong grounds for an appeal. And if you want to know how to appeal, well, I shall be back with another webinar with Matthew Stockwell in a few weeks' time, not just looking at appeals on this particular area, but appeals generally, because I'm afraid that is the sort of situation when that's probably the route that you need to take. Now, talking about further webinars, before we get to the appeals one in a few weeks' time, the next one coming up, really important topic, is PI trusts and welfare benefits, protecting your client's interests. That's with Mike Pace, who's a great speaker, on the 4th of November. I hope you join him then, and I'll be back with Matthew Stockwell looking at appeals a few weeks after that. Meanwhile, many thanks for joining me today. Goodbye.